Very warm good evening to all. Today we'll be discussing different laws under which maintenance can be asked. Now, the maintenance is a very sensitive issue and it is actually very important for daily life. Now, sometimes old parents are involved, wife is involved who is unable to maintain herself. Then there are small children. Also, even if the children are major, that is above 18 years, they are doing their studies. Nowadays, people graduate, they do MBA, they go for a competitive exam. So they are studying, so they are not working. Under this scenario, they need maintenance. So law protects them. Now we'll see few laws which gives maintenance. Now the first law which comes to our mind is 125 Criminal Procedure Code. Now 125 CRP is the easiest thing to go for maintenance because if you have read few judgments, it will say it doesn't require the strict proof. 125 CRPC for asking maintenance, you don't require strict proof. For marriage, if there is a possibility that their marriages has happened, but there is no photographs with them, or there may not be the wedding card, or their marriage not registered. Under this circumstance, 125 CRPC easiest thing. You can file an affidavit. Also now they allow the relatives, near relatives who has seen them as a husband and wife, you can file their affidavits. So 125 CRPC first law which we should know under Criminal Procedure Code. It is again a very important part. It is a religion neutral. So it is general law. So any woman of any religion can go. Even the parents can ask for the maintenance under 125 CRPC. It is very exhaustive. Now next is very recent law that is which came into our country into 2005, that is Domestic Violence Act. Now this Domestic Violence Act is again a very exhaustive act. It not only gives maintenance, but it also gives protection orders such as residence, such also maintenance orders, custody orders to a woman. Also, if there is any kind of abuse, that it may be sexual, physical, mental, that also orders to stop that you can get. Even economical abuse is there in such condition. Also, this is a general law, Domestic Violence Act. Any religion a person belonging to any religion can come and ask for the maintenance. Also, it can ask for protection rights also. It is a quasi civil and quasi criminal, little bit mix of both there, but normally it is taken up in some of the family courts. It is accepted as there are judgments which says that Domestic Violence Act can be you can ask the relief in the family court, but in most of the cases you have to go to the magistrate court. Now next is very important and very popular, that is Hindu Marriage Act. Hindu Marriage Act is one such act where you can ask maintenance when there is a divorce petition is filed. When divorce petition, well, there are two main sections. That is section 24, that is during the pendency of the case you can ask under section 24 of Hindu Marriage Act, and section 25 also you can ask the permanent alimony. That is at the end of the trial, whether your divorce petition is allowed, rejected, or in cases where decree is passed. So you can ask during the pendency also and afterwards also, or at the time of passing decree. Section 25 is very important. Section 25 is not very used frequently, but you should use it because it is one law or one provision which gives an opportunity to a woman who has not asked maintenance, and in future also, even after passing of divorce decree, she can come to the court because of the change of circumstances and she can ask for maintenance. And section 24, as you all know, is very popular, and it is during the pendency of the divorce petition or restitution of conjugal rights case. That also you can ask. Now these are general laws. There is one more law for Hindu. Here we will go through one chapter which is very exhaustive and I would say very helpful also to understand. Now this is Hindu Adoption and Maintenance Act. Mostly it is used when we are going for adoption. Hindus goes for adoption, but there are some sections which are very important here, and there is chapter 3, maintenance. Now if you see here, maintenance of wife under section 18, 19 maintenance of widow, daughter-in-law. maintenance of widowed daughter-in-law. Section 20, maintenance of children and aged parents. Section 21, dependents defined. Now you should see who are the dependents under section 21. See, if you can see, dependents defined. For the purposes of this chapter, dependents mean the following: relatives of the deceased, his or her father. See, the words are his or her father, his or her mother, his widow, so long as she does not remarry. Definitely, if she remarries, her rights changes. His or her son, or the son of the predeceased son of the, or the son of the predeceased son of his predeceased son. See, in the same lineage, you can ask the maintenance, so long as he is a minor, provided and to the extent that he is unable to obtain maintenance. In the case of a grandson from his father's or mother's state, and in the case of a great grandson from the state of his father or mother or father's father or father's mother. See, law is so exhaustive, and see, this law was made some years ago, but everything has been, even for great grandson, they have made the provision. The fifth is his or her unmarried daughter, or the unmarried daughter of his predeceased son, or the unmarried daughter of a predeceased son of his predeceased son, so long as she remains unmarried, provided to the extent that she is unable to obtain maintenance in the case of a granddaughter from her father's or mother's state, and in the case of a great granddaughter from the state of the her father or mother or father or father's father or father's mother. Sixth one is his widowed daughter, provided and to the extent that she is unable to obtain maintenance from the state of her husband. Widow will definitely ask from her husband, but if she is unable to ask from her husband because of some reason, from a son or daughter, if any, or his or her state, or from, this applies to Hindus, from her father-in-law or his father or the state of either of them. 7, any widow of his son or of a son of his predeceased son, so long as she does not remarry, provided to the extent that she is unable to obtain maintenance from her husband's states or from her son or daughter, if any, or his or her state, or in this case of a grandson's widow, also from her father-in-law's state. Now next is his or her minor illegitimate son. Yesterday somebody asked the question, day before yesterday, his or her illegitimate son, so long as he remains a minor. In case the father dies, then what happens? Normally, illegitimate son can take the maintenance from the father. But if the father dies, then what? His or her illegitimate daughter, so long as she remains unmarried. So his maintenance rights are unaffected. So chapter 3 is very important. This act, Hindu Adoption and Maintenance Act, is mostly avoided. But because most of the cases before the court are filed by the wife, and normally, except for adoption, people rarely use this. But if you use it for dependence, it is one of the good law which will be useful to all of us. So this was all about maintenance, various laws which I can take. And for Parsis also there is a different law. The Special Marriage Act is also there. For Christians there is a different law. But this was there was some general laws and Hindu laws. Now we go to the Vidhi. Her name is Vidhi. Vidhi means, I hope you know the meaning of Vidhi. Vidhi means Kanun. Just a minute. Can you unmute yourself?
Yeah, now I can.
Okay.
Yeah, Vidhi means the method or procedure and the law.
And also Vidhi means law.
Yeah.
Just a minute. Vidhi is going to read a judgment which is of 1940 from the Bombay High Court, then Bombay High Court. There was no Supreme Court that time. Emperor versus Biram Sardar, which was delivered on 27 November 1940.
Should I start?
Yes. It was written by a British judge, J. Beaumont and K.T. Sen. Now, You can start from here.
In this case, the accused, other than accused number 6, who were convicted by the additional sessions judge of East Khandesh under section 395 of the Indian Penal Code, appeal against their convictions, we are indebted to Mr. R. Desai, who are represented the accused as amicus curiae for the industry he has devoted to the case and the ability with which he has presented it. The case has some peculiar features. All the accused except accused number 18 are from the village of Saukhera in Taluka Yur, and it appears that on March 5, 1940, the sub-inspector of police of Yur received information that a dacoity was contemplated that night at the village of Shirsoli, Taluka, Jalgaon. So he went to Jalgaon and reported to the sub-inspector of police there and put in a written report, which is Exhibit 8, in which he mentioned the names of the 19 men who he was informed were going to commit dacoity. The sub-inspector of police of Jalgaon and the city sub-inspector of police of Jalgaon accordingly went to Shirsoli with a party of police, some of them armed and some unarmed. Unfortunately, they did not arrive at Shirsoli until about 11 o'clock at night when the dacoity was in progress, and instead of blocking the exits from the village, the police seemed to have entered the village at one end, and when the dacoits started to throw stones at them, the police fired, whereupon all the dacoits ran away from the other end of the village. The result was that full advantage taken and no arrests were made. But the police, suspecting that the dacoits would go back to, uh, s- the result was that full advantage of this information, which at any rate was good as to the fact that the dacoity was contemplated, was not taken and no arrests were made. But the police, suspecting that the dacoits would go back to Sakhera and realizing that for that purpose they would have to cross the river Tapti at one or the other of the fordable places at Kolavi or Thargaon, posted police at those places. But the police did not arrive at Kolavi until about 6 o'clock in the morning, by which time there had been ample opportunity for any of the dacoits to get across the river. Accused number 1 and accused number 2 were arrested at Jalgaon. Accused numbers 8 and 10 among the present appellants were arrested at Sakhera, and the other appellants were arrested at Thorgaon trying to cross the river. All the arrests were made on the 6th, that is to say, in the early morning after the dacoity. None of the stolen property was recovered, and the evidence against the various accused consists primarily of evidence of identification and experience, shows that evidence of identification of those taking part in dacoities at night is apt to be unreliable. I think that we shall have to be very critical in dealing with the evidence because of this report which the police had obtained and which mentioned the names of various persons. The learned government leader has made a great effort to induce us to treat Exhibit 8, report made by the Sub-Inspector of Police of Fuel to his superior in Jalgaon, mentioning the names of suspects as a sort of first information and as affording evidence that the persons named in that report were under suspicion in connection with this document. But it is quite clear that the report cannot be used for any such purpose. The sub-inspector of police has not in his report disclosed the source of his information, and the mere fact that he says that somebody told him that certain persons were going to commit a dacoity in no evidence at all against those persons. If the sub-inspector of police wanted to give proof as against the accused the information which he had received, he would be bound to give evidence as to the source of his information and to call his informant, and that, no doubt for sufficient reasons, he was not prepared to do. All that the report amounts to, therefore, is that the sub inspector of police did receive information which caused him to think that there might be a dacoity at Shirsoli and which induced him to go to Shirsoli with a police party. But his information affords no ground for suspicion whatever against any of the accused, and we have to see whether the evidence against the various accused is sufficient to justify their conviction. The learned sessions judge and the assessors were for the most part unanimous in believing the different witnesses, and this court always differs with reluctance from the unanimous opinion of the trial judge and the assessors as to the credibility of witnesses. In this case, I am prepared to assume that the witnesses who were regarded as honest by the learned sessions judge and the assessors were in fact honest, but as to some of them, I think they were not in a position to be certain of the facts to which they deposed. I think that the risk of mistake on their part in some cases too great to be run. His Lordship then discussed the evidence against the accused and found that the evidence against accused numbers 1 to 5, 15, and 18 was not sufficiently reliable. Mr. Desai has also raised a point of law which is occasioning a good deal of trouble to the high courts in India, and that is the question whether information leading to the discovery of a fact and prima facie admissible under Section 27 of the Indian Evidence Act is inadmissible, having regard to the terms of Section 162 of the Criminal Procedure Code. That trouble started with the decision of the Privy Council in Narayan Swamy versus Emperor. In that case, their lordships pointed out that Section 162 of the Code of Criminal Procedure, which prohibits any statement made by any person to a police officer in the course of an investigation under Chapter 614 from being used as evidence for any purpose except as mentioned in the section, is wide enough to include a statement made to the police by a person who either at the time of the statement was or afterwards became an accused, and as far as I know, that view had always been acted upon by his court. Their lordships further pointed out that on that reading of section 162, there would to some extent be a conflict between that section and section 27 of the Indian Evidence Act, and they observed that the question might arise whether section 162 pro tanto reveals the provisions of section 27 of the Indian Evidence Act, or uh, whether section 27 of the Section 27 of the Indian Evidence Act is saved by Section 1, subsection 2 of the Criminal Procedure Code, and their lordships left that question open. Since that decision, the matter has been considered by four of the High Courts in India. The High Court of Madras, Subhay Tevar in Re 1939, Med 947, and the High Court of Patna, King Emperor versus Mayadhar Kothal, 1939, ILR 18, Pat 450, have taken the view of Section 27 of the Indian Evidence Act is not affected by Section 162 of the Criminal Procedure Code, being saved by Section 1 Clause 2. On the other hand, a full bench of the Lahore High Court in Hakat versus the Crown 1940, Lahore 242 FB by majority have held that Section 27 of the Indian Evidence Act is pro tanto repealed by Section 162 of the Criminal Procedure Code. And the same view has also been taken by a full bench of Allahabad High Court in Emperor versus Baldio 1940, Allahabad 396 FB. Having read the various judgments of the other high courts, some of which extend to a considerable length, I am reluctant to add to the number of judgments on the point, but the lower courts in this provision are entitled to guidance. I prefer the view taken by the high courts of Madras and Patna to the view taken by the high courts of Lahore and Allahabad. Section 1, subclause 2 of the Criminal Procedure Code reads, in the absence of any specific provision to the contrary, nothing herein contained shall affect any special or local law now in force. Most, if not all, of the learned judges agree that Section 27 of the Indian Evidence Act is a special law in force at the date of the passing of the amended Section 162, and that point seems to me beyond question. It is a law applicable to a particular subject within Section 41 of the Indian Penal Code. But the view accepted in Lahore and Allahabad is that Section 162 amounts to a specific provisions to a contrary, because the prohibition therein is expressed in the most clear and emphatic way in terms. But surely, much more than that is required. Section 1 subclause 2 enacts a rule of construction to be applied in the interpretation of the code. That rule is that where there is conflict between the code and a special law, the special law is to prevail in the absence of a specific provision to the contrary. But the provision must be to the contrary of the rule of construction and not merely of the special law. The section presupposes a conflict, and a conflict is nonetheless a conflict because it is clear for all to see. Reliance has been placed on the use of the word specific rather than express. I may myself incline to think that specific provision is a stronger expression than express provision and means a provision clearly expressed. I do not see how a provision arising by implication only can be said to be specific. But if this is going too far, I am clearly of opinion that the language of the code giving rise to the implication must at any rate be so directly contradictory to the special law that it can be affirmed with certainty that the legislature intended to override the special law. There is, however, nothing in the language of Section 162 which suggests that the legislature had in mind Section 27 of the Indian Evidence Act. The language of the two sections is quite distinct, and to a large extent, the respective subject matters are not identical. Section 162 deals with all statements made to a police officer in the course of an investigation. Section 27 of the Indian Evidence Act merely deals with information received from a person accused of an offense in the custody of a police officer, which leads to a discovery. The two sections only overlap in respect of statements made to a police officer in the course of an inquiry, which lead to a discovery. It seems to me impossible to hold that Section 162 contains a specific provision that Section 27 of the Indian Evidence Act is not to prevail over it. Another argument which repealed to the High Court of Lahore and Allahabad is based on the history of two sections. It is said that the legislature must have known when they amended Section 162 in 1923 that originally the subject matter of Section 27 of the Indian Evidence Act has been included in the code. That prior to 1893, when the terms of Section 162 were in conflict with Section 27 of the Indian Evidence Act, the latter section was expressly saved from the operation of the former section, and that the court is bound to assume that the omission to insert in 1923 an express provision saving the operation of Section 27 was deliberate. More particularly, as in the section as it existed from 1898, there was an express saving of Section 32 of the Indian Evidence Act. I do not suppose that anyone seriously doubts that the omission of the legislature in 1923 to deal with Section 27 in one sense or another was due to the fact that it was not present to the minds of the legislatures that the amendment of Section 162 would appreciably affect Section 27. But if the board must deal with the matter pedantically, one may suggest that the omission to save Section 27 may have been due to a just appreciation by the legislature of the true effect of Section 1 subclause 2 and to a reluctance to insert an unnecessary saving clause in respect of Section 27 merely because the legislature of 1898 had inserted such a clause in case of Section 32. This explanation, if not conspicuous for its probability, seems to me much more probable than the hypothesis that a legislature, realizing the conflict between the amended Section 162 and Section 27, and intending to repeal the latter section 210 and thereby to alter the law as it has existed for 50 years, nevertheless omitted any mention of Section 27. In my opinion, to read Section 162 of the Criminal Procedure Code as overriding Section 27 of the Indian Evidence Act is to ignore the terms of Section 1 subclause 2 of the Code. The point is really not of very much substance in the present case as against the accused whose appeals have been dismissed. But as I have said, the lower courts are entitled to have a lead from this court on a question which arises so frequently, particularly in dacoity cases, as to the admission of evidence under Section 27 of the Indian Evidence Act. I think that those courts may safely proceed on the assumption that at present the law has not been altered by anything which the Privy Council said. In the result, the appeals of accused numbers 1, 2, 3, 4, 5, 15, and 18 will be allowed, and the appeals of accused numbers 8, 10, 12, 13, 14, and 16 will be dismissed.
Thank you. Vivi. For a minute, we will see these two sections. Section 27 in the Indian Evidence Act. How much of information received from accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of police officer. So much of such information, whether it amounts to a confession or not, as read distinctly to fact thereby discord may be proved. See, section 27, you must have heard Panchanama. It is too detailed, but as Vidhi has read this judgment, I would like to tell you that this judgment wants to differ between two sections, that is 162 CRPC and the section 27. In both the matters, actually, the police discovers some information and which they take down as an evidence, as a statement. And under 27, they may take down the Panchanama or the any fact which is newly discovered. Now, section 27, let's read. It is about the how much of information received from accused may be proved. Now we go to the section 162 of the Criminal Procedure Code. Now see, statement to police not to be signed, use of statement in evidence. Now, this is again an information taken by police. In both the cases, the police takes the information. No statement made by any person to police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it, or nor shall any such statement or any record thereof, whether in a police diary or otherwise, any part of such statement or record be used for any purpose save as any hereafter. We'll go to section 2, which was discussed in the judgment. See, this is for your information that any statement given to the police by witnesses will never be signed. The highlight is statement to police not to be signed. The reason behind that, they should not force anybody to sign which he does not want. That is the reason legislature or law framers have made the provision that a statement of witnesses will never be signed. Now, nothing is this section shall be deemed to apply to any statement falling within the provision of clause of section 32 of Indian Evidence Act 1872. This is about the a person while dying, make a dying declaration. This is again very important, or to affect the provision of section 27 of that act. This is what Vidhi read. To affect the provision of section 27 of that. See, section 27 of the act, the Panchanama will be signed by the Panchayats who gives the information or who are present, who are testifying a fact. So actually it is too deep study for the newcomers here. But otherwise, this is one section 27 and of Indian Evidence Act and section 162 of CRPC. This you should know thoroughly when you are running a criminal trial. Now, the third part which I would like to take today is about how do we prepare for the cases which comes to you. Now, tomorrow, suppose a civil matter comes to me and I have no idea because I have never done a civil case in the past. What is the remedy left to me? One remedy, I go to a senior lawyer or any friend of mine who does the civil matters and take her or his help. But there is a possibility every time this help is not available. The reason may be they may have also not done, because my friends will become from mostly those who are doing the criminal or family matters. So in these matters, what do we do? Now, suppose I will take one example. You get a divorce matter, a matrimonial dispute. Either it is for maintenance, or either it is for divorce, or either it's for restriction of conjugal rights. It may be under special marriage act, it may be Hindu marriage, it may be Parsi law, or it may be a Muslim law also. What is the remedy left to you? The easiest thing I would say, it is a secret trick of the trade of who becomes lawyer, that you go to any website or library and start reading judgment which are related to the facts of your clients. See, normally the drafting starts after you find out the judgments. Otherwise, people file the case and then they find out the judgment. That is a wrong practice. First, you have to read the judgment, take the points, note down the points, see whether facts are similar, and read judgment. You can use those words from that judgment. If it is an accident case, suppose it's a criminal trial, it comes to you. For prosecution, there will be a prosecutor. But if you are for accused, how we will go ahead? Now, to go ahead with the criminal trial, suppose I take a 498 matters or an accident matter. I have to read few judgments of if you are from Mumbai, then you can read the Bombay High Court judgments. and also Supreme Court judgment. You can also read from other high court judgment as well. But normally, when you are running a trial, it's better to read the respective high court judgment where you are situated, and also the Supreme Court judgment related to the same. Suppose it's a capital punishment. Suppose it's a murder trial. So you should find out 302 IPC matters and what were the points taken by the prosecution, what were the points taken by defense, what is the court observance, and how cross-examination question was done. Even if you go to indianqanun.com and put a cross-examination of the respondent husband, you will get so many judgments. So the key to prepare for any case is to go to the judgments, read it, and make. I will tell you about my personal experience. I got in the beginning of my career an accident case, and it was actually very difficult case. And from some senior law, it came to me. So I was like, how do I deal with? The best thing I started reading all the accident cases. And after reading 20 judgments, I could actually make out few points for the cross examination. And that is how I won the matter. My accused got acquitted. But then I think the complete credit should go to my reading of judgments. And this is one thing which I learned in the beginning. So you should be your own eklavya in the matter. There will be seniors. I am not saying you don't take the help of seniors and friends, but they will be busy. They will be having their own uh, work, and they will not be available at the same time. Same goes for bail matters also. Suppose you want a bail in the or for in 498 matters, you go for anticipatory bail. So reading only the section will not help. So if you go to library, if you read 438 CRPC, there are some judgments given in the commentary. Always try to see, reading direct is a different thing, and reading a book with commentary is a different thing. So if you read a book which is with the commentary means it will be discussing all the judgment in favor also and against also. For domestic violence case also it goes same. So civil case or any again you can take property cases. Now a lot of property matters are coming up because now women are given the equal rights of mostly Hindus. Now these cases are property matters will keep coming to you. Now what do? You start reading the judgments of the last 20 years, 10 years. You can go back to this. Today Vidhi read a judgment which was back of so back it was in the year 1940. But still it is a valid judgment. It is upheld because it is giving a difference between section 27 and 162 CRPC. Because both are dealing with the information given to the police. But how and how different they are, that we should know. So preparing for any cross examination, for evidence, for giving arguments. Now the most difficult part sometimes, how do I argue the matter? Now argument is always on the law point, not on the facts. The facts are something which comes into evidence, and you have every opportunity to cross examine that person in the box. But when it comes to the court, you have to point out what is the